And so we want to test the question again of whether the obligation to obey the law applies only when the reasons behind the law apply, or whether you might have an obligation to obey the law even when the reasons behind the law don't apply. And this is really important because one of the most famous modern legal philosophers, Joseph Raz, takes that first view quite famously, that in his normal justification thesis and his related theses, that the obligation to obey the law, the authority of law, depends on the reasons behind the law applying. And if the reasons behind the law don't apply, then the obligation to obey the law doesn't apply, doesn't attach. My answer to the question, I don't want to spoil everything in the book, right? So we're in all the fun, is probably. The book I'm saying, yeah. In the book, I'm trying to make the case of how or why there would be an obligation to obey the law just because it is the law. But this then leads us to a problem, a question. The other side, the second topic I said we like to focus on in jurisprudence, in philosophy of law, is Nazi law. If there's an obligation to obey the law just because it is the law, well, what about Nazi law? We have the famous ancient maxim, an unjust law is no law. And coming from my wonderful and beloved Villanova University, I'm contractually obligated to mention our patron saint, St. Augustine, who, so checking the box there, that's like this is like my Villanova version of the secret password for the CLE credit on the live stream, right? Right, that Augustine famously said that in whichever translation, right, without justice, what are kingdoms but great robberies? And right, so the idea that, again, borrowing from or building on this idea that an unjust law is no law. So if there is an obligation to obey the law just because it is the law, what do we do about unjust laws? And let me take the problem a little bit further. When we say an unjust law is no law, what do we mean by that? Do we mean, in fact, like it says, this is the law school is the worst place for me to blank on this, but was it Justice Harlan or someone said no law means no law? On a First Amendment case, was it Justice Black? Thank you. Oof, that's I hope this isn't recorded. Right, that said no law. Means no law. Is an unjust law not a law? Do the Nazis not have laws? It sure looks like there's laws in Nazi Germany. Like if you just kind of landed there from another planet and observed, say, well, isn't it the case that there are laws? So do we want to argue that unjust laws are not laws at all? And if they are not laws, what do we do about a legal system that seems to be unjust? Now here, in this crowd, there's probably more familiarity with this. Here, it's important to raise the positivists, people who argue, scholars in the field of law who argue, the legal positivists, who think that we can identify law without respect to normative criteria. People who argue that we don't define law by its relationship to morality. See, class is paying off, right? This is what it was all about, right? It was all building to this moment. And so, thank you for being a good professor. According to the positivists, that the injustice of Nazi law is not a problem because we don't define law with respect to moral criteria. So what makes law law? For the old positivists, it had something to do either with punishment or sanctions, or something to do with habits of obedience. So you might find late 19th, early 20th century positivists saying that the part of law that's really law is the sanction, the penalty, the punishment. And without punishment, you don't really have a law. You basically have a suggestion. And so the heart of law is to be found in the punishment. In the same kind of category of scholars, maybe different people, you see sovereignty as defined as he who is habitually obeyed and habitually obeys no one. So the idea that authority is rooted in obedience. And these are both, in their different ways, positivist attempts to define law without respect to moral criteria. They're saying that we don't need to know anything about the justice of the laws involved in order to recognize that they are law. In the older case, right? So if you have a command and a punishment, you've got the law. And it doesn't matter whether that command is a good command or a bad command. Again, with the sovereign, it doesn't matter if the sovereign is using the authority in good ways or bad ways. But if the sovereign is habitually obeyed and habitually obeys no one, then it is the sovereign. And the sovereign's pronouncements in whatever form are the law. Which is to say that we have non-normative criteria for identifying the law. The new positivists, and this is led particularly by H.L.A. Hart, who I criticize extensively in the book. He's not all bad, but I'm definitely on the other side. And Hart says that that's not a good way of looking at it. We should look at law in a different positivist way as rules based in social practice. And this is one of Hart's most famous things that's taken on board, in fact, by many non-positivists, as I'll say later, which is to say that we just need to see if the law meets the criteria for law that is socially accepted in that society. So in this society, if we accept that a law becomes a law if it's passed by a majority of the legislature and signed by the executive, then we have a law. And again, it doesn't matter the content of the law. This can be, we can consider this a just measure or an unjust measure, but it's a law if it follows the rules. Now, why did Hart do this? Why did Hart reject the old way of thinking about the law? And again, we could take an example, the idea of law as punishment. And Hart sets up the following example. He says, imagine that someone holds a gun to your head I'm kind of riffing on the example, but someone holds a gun to your head and demands your wallet. If you got away without giving up your wallet, if you get away, we would not look at that and say you did something wrong, that you failed to fulfill an obligation you had to give up your wallet. In Hart's terms, Hart says that you were obliged to give up your wallet, but not obligated to give up your wallet. That the mugger doesn't create for you any obligation such that we would say you ought to give up your wallet, and if you don't, you've done something wrong. And Hart says, but the problem is that's what the old positivists think the law is like. The old positivists think that the law is a mugger, that what makes law is the punishment or threat of punishment. And he says that people don't relate to the law in that way. They relate to the law as though they have an obligation. Not obliged, but obligated. Maybe obliged also, but obligated. He says, and this brings us back to the traffic laws. It says, think about the red light. It says from what he calls the external point of view, again, just observing the intersection from above. Right now it's easy because we've got drones and you can just imagine the drone hovering over the intersection and recording what's going on there. It says that the red light for the external observer is just a sign that people are going to stop. It's just kind of a prediction of regular behavior. But from the internal point of view, as he calls it, from the internal point of view, people driving take the red light as a signal to stop. It's an instruction to them. It's a standard against which they measure their behavior. If I stop, I've done something right. If I go through the light, I've done something wrong. It's more for them than just a prediction of regularized behavior. And it's more for them than just the threat of coercion. They think that they ought to stop at the level. So where we are up till now, we have a claim that I'm happy to advance that there's an obligation to obey the law because it is the law. But then we have a puzzle that says, well, what about unjust law? And if your answer is that unjust law is not a law, that Professor Mark isn't making the claim that you have to obey the law in every case, in every situation, that there are exceptions, that people can engage in civil disobedience, that an unjust law is no law, then are you simply denying what Hart's accusation back to this position is? You're just denying reality. You're just looking Nazi law in the face and then just shutting your eyes and say, I don't see any law there. How does that work? And the positivist answer to that, as I was just saying, is that, well, we can solve that problem because we should define law with non-normative criteria. We should say that there are rules that don't depend on the moral content of the law, just rules about how to pass laws that define law without any underlying moral judgment. And that's how we can see law as law. Now, there's a very good answer for this that I think comes from, in part, my favorite scholar on this is John Finnis, who I feel an affinity toward in part because he was my teacher's teacher. So, sometimes the person, taking from the old German model, the person who is your, dissertation advisor is your Doktorvater, and forgive my bad pronunciation. So John Finnis is my Dr. Grandfather, as it were. And in an article I commend to everyone, Law and What I Truly Should Decide, he says that an unjust law is like putting the label medicine on a bottle of poison. It's like, you can call it anything you want, but if it doesn't serve the purpose that it's for, it just isn't that thing. Just calling the poison medicine doesn't make it medicine. It's still poison. And he uses that analogy effectively, more effectively than I'm doing now, but effectively in the article to make the point that we can't even make sense of the enterprise of law without the component of justice, which is to say, he also gives another kind of good example in the article where he talks about like a school child going to complain to the teacher and like the teacher's intervention only making sense if the teacher is weighing, there's like a bullying incident in the playground or something, it only makes sense if the teacher weighs in on the side of justice, right? If the teacher just comes and punishes the victim or something like that, like the teacher's authority doesn't really make any sense in that situation. It kind of defeats the purpose of having the adult in the room, as it were. And so too with the law. We couldn't even explain why we would have law as an institution without appealing to notions of justice. And that's the direction that I go in there. But for our purpose that I want to go in the book. But for our purposes here, I want to say something in a way that's like a little bit more narrow, or at least a little more circumscribed in the time that we have. And that's to focus you on my critique of Hart, which takes up a substantial portion of the book. Because Hart, first of all, Hart is enormously influential. And a lot that has happened in jurisprudence since Hart is because of Hart and is built on Hart. And the claim that I make repeatedly in the book is that a lot of philosophy of law is an edifice built on a shaky, cracked, flawed foundation. And so it's really important. And in reading what people are writing today and in recent years, kind of building off of Hart, I was shocked by how kind of the original sin, kind of the errors in Hart's own theory just get built into the later theories, never really solved, never really addressed, and which is why the later theories, even with all their cleverness and sophistication, don't really ever get to the bottom of the matter. And here's the particular critique that I would like to call your attention to. And we're all set up for it based on what I've said already. I hope I didn't belabor the point too much previously, but it was it's all for the payoff here. Hart's big innovation of the internal point of view, the obliged obligate distinction, is to remind us the idea that the other positivists, the old positivists, were wrong because they treated the law like a mugger. But people don't relate to the law like a mugger. They relate to the law as though it confers upon them an obligation to obey the law. But as a positivist, Hart is committed to a non-normative definition of the law, a definition of the law that doesn't include moral criteria, in which case his theory can in no way account for why obligation is the central defining feature of law. Why does anyone think that he or she has an obligation to obey the law? Now, obviously, there's a possibility here, which is like, well, it's just mass delusion. No one has an obligation to obey the law, but everyone thinks that he or she has an obligation to obey the law. I mean, okay, that's a possibility, but that is, I think, a profoundly unsatisfying possibility, right? If that's the answer, then we've just kind of like, bottomed out at something silly in a way. And so again, there's a fundamental contradiction here whereby Hart wants to say that law in its essence is a non-moral entity. Not that it can't be directed toward justice or it can also have justice, but that for law to be law, we don't need any moral content. That Nazi law is law just as much as American law is, just as much as Canadian law is, just as much as anything else. At the same time, law's defining characteristic, when it is better understood than his predecessor understood it, is that it carries obligation. And I think that those two things simply cannot be reconciled. We cannot say at once that law in its definition requires no moral criteria, and also the thing that makes law is that it confers a sense of obligation. Because where would that sense of obligation come from? Why would it exist? For that reason, I want to reject the positive. Well, it's not new, of course, to reject positivism. There are, John Finnis, other natural law thinkers, and probably others too, who want to reject positivism, insist that we do need moral criteria for the law. But I also want to go further than that and also reject his adoption of rules instead of commands. I think that for a lot of reasons I say in the book, I think that Hart's reasons for throwing out commands in favor of rules aren't as good as he thinks they are. But one of the reasons that I want to bring it back is because I think that unlike rules, and Hart, I think, is aware of this and is doing it for this reason, but incorrectly, that commands carry, the idea of command carries it with it the sense of obligation. Now, not all commands obligate. If I just command Sig right now to do something, right, no reason he should listen to me, of course. But the very idea of a command, just as a structure, as a form, as a placeholder, is something that carries with it the sense of the intention to obligate. And so I think Hart's reasons for throwing out command, which I'm not going to get into here, aren't that good. And I think when he does it, he unwittingly actually loses something that he should have kept. Now, that's not to say, and shout out to all my common law people, right? Not all law is command in the strict sense of a sovereign dictating a decree or something like that. But I think that, and again, I continue to wrestle with this, but I think that command is at least the central case of law, and that then there are other versions of law, but they are all law with reference to the central case of law as command. Now, I'll give you two short implications of this as it relates, and then try to, in much less time, give you some of the other parts I promised. One of the things that Hart talks about in the book is the post-war trials for Germans, so after World War II, and he says, well, here's why this is such a quandary. We're putting people on trial for things that were legal at the time that they did them. How could you do that? And I think that Hart is is onto something, but I think Hart is actually wrong about why this is a quandary. Why is Hart wrong about why this is a quandary? Hart's wrong because for Hart, to say that something is legal is not to say that it carries with it any kind of moral obligation. And so what defense is it to say, if you're Hart and you think that law is not law by reference to any moral criteria, law doesn't have a justice component necessarily, and therefore you can't account for obligation, then what defense is it to say, well, this was legal when I did it, so why am I being held accountable? Legal doesn't mean anything. Legal doesn't mean legally obligating, doesn't mean morally obligating, and it can't mean that because we define law without normative criteria. And so I think that the way to make this a real quandary is to say, well, there is in fact that law should be defined with reference to moral criteria, and therefore we could, if I make a persuasive argument in the book, we could say there is a moral obligation to obey the law. And now we have a real quandary because now we say that, well, on one hand there was a moral obligation to obey the law, and then on the other hand there was moral obligation not to do the things they did in the name of the law. Now, it might be the case that we also think it was a pretty easy call in some cases, that the moral obligation to the law was vastly outweighed by the moral evil that was being done in the name of the law. That might be the case. But I think it's a much better question for starters, at least, if we say that we've got moral obligations on both sides. Because if all we've got is moral obligation on one side, then it doesn't seem to be the quandary that Hart thinks it is. A second thing that I'll bring up is civil disobedience. One of the interesting features of civil disobedience, as you'll remember, is that a standard feature of civil disobedience is, and I'm not saying it should be this way, maybe it should, but it is accepting the punishments for breaking the law. So kind of you break the law openly, but then not then fleeing as a fugitive from justice, but accepting the punishment. And why should that be? Where is the justice in accepting the punishment? If the law is unjust, then the punishment for breaking the law should be equally unjust. Why would one accept the punishment? And I think we could think of some prudential reasons why that might be the case. But what I'd like to say here, in line with what I've been saying to you today, is that if there is an obligation to obey the law, then even when breaking this particular law, and this also with reference to the Credo, actually, which we read together yesterday, that if there is an obligation to obey the law, then in one sense, the person has done the right thing in civil disobedience and breaking the law. But in another and smaller sense, the person has done the wrong thing by breaking the law. And there's a reason to explain why and therefore, there's a reason to explain why you could say at the same time that it is just to break the law and also just to accept the punishment. Again, only if we think that there is a moral obligation to obey the law just because it is the law. Because otherwise, I don't think we can find any reason why, any principled reason, again, maybe prudential, but any principled reasons why one would accept the punishment. Okay, let me figure out the best way to wrap up here. Okay, I think I covered a lot of that stuff. That's good. We'll skip that. Okay. Some other reasons why the themes of the book matter, even beyond this maybe intramural debate among analytic jurisprudence about the concept of law, as Hart says, or per my title, for intentionally the nature of law. It's not just a concept, it's not just an arbitrary concept, it's got an essential nature. And the first thing is that what I try to do in my definition of law is, or what I do for my definition of law is define law as a set of commands oriented to the common good. And the emphasis on the common good, I think, is profoundly important. I mean, I think as a philosophical matter, I've tried to get at the truth of the matter of what is actually correct. But we live, as everyone knows, and as we discussed very amiably last night, I will say, we live in a very polarized time. It's a cliche to say that. Everyone knows this. And I think it's really important that we understand politics as a contest between competing visions of the common good, and not just a contest for power. Now, of course, that opens me up to, a rebuttal that says, well, you're in a contest for power, whether you like it or not, and that's just wishful thinking. But I think in recalling, and this goes all the way back to the opening of Plato's Republic, the most important work in all of political theory. This is the very opening of the book, right? It's not just about numbers, it's about reason, it's about persuasion. And I think that at a minimum, we should remember what politics should be, and at most, hopefully, what politics could be. And so I think that reminding ourselves that law is an enterprise primarily directed at justice, and not primarily directed at imposing our will on those of fewer numbers, I think can have a salutary effect. Relatedly, and this was, whatever side you're on, you may have noticed that we had recently a weekend of No Kings protests. I say that not by way of endorsement or condemnation, but to remind you, like with most good things, right? The ancients said it first, and right, I remind you again of St. Augustine's line that kingdoms without justice are great robberies. And I think and again, this is a fully bipartisan remark, because I can say these things and my students will take it whether in their heart of hearts they hate Trump or they hate Biden or whoever it is, right? It's a equal opportunity slogan, right? We have live questions in our politics today about when a state becomes a tyranny. And thinking about, right, if I'm going to defend law, if I'm going to define law with normative criteria, that means we have to think really carefully. That means there's a point at which a line is crossed, and the authority, and I'm not suggesting that we're there by any means. There's a point at which law can lose. Law as an enterprise, a legal system can lose its moral authority, lose its justification. And then more broadly, and this can be relevant kind of in any area of life. I have a friend who told me who read the book and then wrote to me to say it helped him think about his parenting and authority in that respect. One of the things I do in the book is I talk about how legal obligation might be built partly off of models of moral obligation and religious obligation. And there's more to say about that I could say now, but if there's a way, moral obligations come to us in part without any command, in the way I'm suggesting law does, they're just reason. So whether that's the moral obligation to treat all human beings equally, or whether that's including the moral obligation not to kill them or assault them or enslave them or anything else like that. So that's an example of of us having reasons without commands, as I say. And then we've got religious obligation that, again, depending on, we live in a time of, a religious pluralism, religious contestation. We had a few remarks last night about thinking about like how we define and understand the entrance of Muslims into American public life. And it's interesting as we become a increasingly pluralist country, thinking of the way different religious models of religious obligation contribute to our thinking of authority. And in some cases, I think in a way that is opposite from the way we think of moral obligation as reasons without commands, but religious obligations as commands without reasons. And I think that legal obligation follows from neither of those, but in a way is both, but commands and reasons together, and can't be complete without both. And so I think that, again, it can, although this is not my aim to address it in the book, I think it opens up good questions for us about, more broadly, about not just the nature of law, but the nature of authority, and how we understand the normativity of obligation in general. Okay, so that's not a big flourish to finish with, but to make sure that there's time for questions, I want to thank everyone for their kind attention, and also everyone on promise is out the door at 1, but I will be happy to stick around if anybody wants to talk after. So thank you.
Let's transition to Q&A. So, Anush.
Yeah, so this is great. I don't know very much about this at all, and I think my memory of art is all reading other people who talk about art.
Sure.
So but I'm trying to think what he would say in response, and maybe this is just me, but I had always understood the idea that law doesn't have to be legitimate to be law. And in particular, if we think about what might make it obligatory in the way you're describing, I wonder whether we might just think of kind of levels of generality about what we're describing when we talk about law. And in particular, if we just go back to your first example, traffic light, I mean, there's, as you sort of were saying, there are a whole bunch of things one could say about that. Like, now the technology is going to change so that, I mean, in California, we have some of these here, but basically in that sort of circumstance, when you come up to the red light, there's some kind of sensor and the light will just turn green. So so we have, we've sort of solved the problem of obligation in some. But I wonder, so as at least I thought about HART, the way I always thought about it was, when we say, majority vote the president signed something, whatever it is, what we're talking about is procedural legitimacy. So there's no moral thing, except to the extent that there's a moral legitimacy in the procedures we've set up as a collective to establish the line between what is and isn't law. And so as long as you think the procedure for creating law is legitimate, then that's what triggers your obligation. And that, I don't know whether that's right, but if that's right, then I guess there's a moral component to it at some level, but it's at a level of generality that's quite different from where you are in terms of what you're describing as morality. It's just a kind of meta morality, I guess is what I would say. It's not, yeah. So anyways, I'd be interested in your thoughts.
No,
and I haven't read the book, so
of course, yeah. So great question, and I think you might be right. Who knows what Hart would say, but I think you're tracking the right train of thought here. But then my question is, and I have puzzled over this for a while, and I think it does or doesn't bottom out, whichever way. It doesn't cash out in the end because there's going to be with this procedural legitimacy, there's going to be two sides of the line. There's going to be is law and isn't law, right? If it has procedural legitimacy, it is law. If it doesn't have, it isn't. But then what? Or so what? So if it has procedural legitimacy, does that mean I have to do what it says, or I don't have to do what it says? And I think you would have to say, well, if it has procedural legitimacy, I do have to do what it says. And then I say, well, why? And then I don't think, and again, if not for the fact that, okay, so first of all, and then I say why, and I don't think that can be answered without appeal to normative criteria, which would be okay, except for the fact, I will let you come right back, except for the fact that Hart's whole project turns on this distinction between obliged and obligated, right? That what makes it not a mugger is that it's not just this isn't like stimulus response, right? Yeah, you want to come back in and go? Yeah.
So I think again, what I think would the morality is in the procedure. That is, the procedure is democratic in some sense. So if there's massive gerrymandering and actually these people are not in no way representative or something, and we think the obligation comes from the democratic legitimacy of the lawmaking process. Again, you can call that moral if you want to call it moral, right. But I'm not sure I would call it
that's
moral.
The metamoral. Right. That's the metamoral.
That's the metamoral
for you. Yeah.
The way I would say it, right?
No,
and so
yeah.
So that would just be the frame that I would say. I mean, and again, I don't know that Hart exactly would say that, but that's the idea is it doesn't have to be democratic, right? if we all think legitimately that the king is the king because, you know,
Right,
God
yes.
gave him the power or whatever it is, and we all agree, that's the social
Exactly.
acceptance that he would say. And that, again, I think then the procedural way in which the king determines what is and isn't law is, as long as we think that it
Yeah,
is legitimate,
totally, right?
then
And
we
so,
have an obligation.
yeah. And so, yeah. So first of all, I want to acknowledge, I think we're having the exact right conversation here, right? Like these are all the right questions. I'm fully with you on that. I just think like it really fails for Hart, and for the reasons that you're saying. Because the first thing I was going to say back to you was when you said, democratic legitimacy, and not against you, but along the lines you're saying, is because for Hart, if it were 40% instead of 51%, and that were socially accepted, then that would be valid too, right? And valid is the term he's going to use here to distinguish between moral legitimacy and legal validity, right? And so, and I know I'm not saying that against you either, but so there it is, and you already acknowledged that because you said, well, what if it's a king? No democracy at all. And then let's take it further, and then you said, well, as long as we have like the acknowledged procedures, whatever. So let's say it's a kind of like riff off the legal realists. Let's say the valid procedure is like whatever moves the king in the morning after breakfast, like, and maybe he's got indigestion, and we don't like the decree, or maybe he had a good night's sleep, and we do. But as long, if the accepted rules of our society are whatever the king utters, right? Then that's going to be it, and Hart can't rule that out. And if that's the case, then the procedural legitimacy has become so thin as to make the meta morality moral in only the very, very, very barest sense. And also, I would ask simply, like I was going to say, well, what is meta morality? I mean, it was kind of say, because think about it this way, right? So the king, we're agreed, it's just everyone accepts that it's whatever the king utters at any time, and that he says, this is the law, it is the law, it doesn't matter. It could be arbitrary, it could be cruel, could be whatever it is, but we're all agreed on that procedure. In that case, so I wake up in the morning, the king is there, and I say, well, do I have to do what the king said or not? Do I have an obligation to do it or not? And I think and if my answer is, well, yeah, I don't want to go to prison, right? Well, now we just have law as mugger again, and you know that, right? But what is there any other way that you could answer the question that wouldn't then appeal to the very thing that Hart is trying to rule out? And that's what I'm saying.
Right. And again, the Hart way better than I do, but why is it that just because something is law, it's necessarily obligatory? I mean, I guess maybe that's
because, well, in a way, because Hart wants to say that what makes law is that it carries the sense of obligation. Now, again, you could have and that's what I said, the mass delusion, you could have a purely psychological thing, like there is no such thing, it's just a psychological phenomenon. But if that's the case, also, like, I'm just taking my ball elsewhere to play, right? Like if you're saying like, well, that's it, it's just a psychological phenomenon, there's nothing philosophical going on here, then okay, then we're just operating in different lanes, and so be it. But yeah, all right, let me see if there's, so I would do this all day with you, obviously. Yeah, you pick, I pick, there's one here and one in the back. Would you try to do both? Yeah. Sure. Well, yeah. Or three. Yeah. Sorry. Go ahead.
Just to shift slightly, I mean, I'm loving this. We could also sit and listen,
right, yeah.
But I want to maybe touch on what you spoke right at the end. So, to give a brief, I am not a scholar. I'm a practical law professor, right? And spent most of my life working in the court system. And I'm curious about sort of
real life. Yeah. I don't know. I take it in real life.
But sort of, I mean, you kind of gloss over it a little bit. But like, how is the common law when we have these competing notions of the common good, and that's even a phrase,
sure.
Adrian seems to think that the common good is whatever's the best for Adrian is the common good, right? But when you have sort of, right, again, like, we still treat law as this normative system, this normative thing within society. But when you have, I mean, I won't use the big one, but let's say something like the death penalty, right? Where, for some people, any participation in that is morally reprehensible, right? And for others, it isn't. Or gay marriage, right? Even like the idea of issuing this,
whichever issue, sure,
yeah, stamping this, right? And again, so I'm curious, right? Again, this is a big loss, but the 20th century, especially the 20th century, sort of evolution of American common law seems to be right. We have left a lot of things to sort of private ordering, and we've left the public ordering out. a lot of the backlash we're seeing at the moment is that there seems to be this movement in American jurisprudence, at least on a practical level, maybe not on the theoretical level, but to reestablish public ordering for moral questions. But when you have this society where that, again, right, the moral obligation is so divergent, how can the common law, how can the law remain this normative thing? How can you make statements about what legal obligation people have when, again, if it's striving towards the common good, is the common good just what, what 5 people in Washington think it is?
Right. Well, I mean, no, that's why we have.
One person in Washington.
Right, or one, right. But no, I mean, that's, yeah, so, right, so that's why we have, well, okay, I mean, that's more than I can address here, but I say that's what, so that's what elections are for. This actually touches on what we're saying, although in a slightly different vein, is that given that, politics is or should be like a contestation between competing visions of justice, of the common good. We do need a settling mechanism because we do actually need, and none of them is the neutrality is an illusion, right? It's going to be settled. Things will be settled in one direction or another. Even neutrality is a choice between neutrality and non-neutrality, and so that's another talk. Neutrality's out the window. And so we need a settling mechanism. The settling mechanism we have here is elections, is democracy. Now, exactly what that means for like district judges and executive orders, and right, so we have to, but there is plenty of room to say, right, within the determinatio, within the matters of indifference, within the realm of prudence, that there's a multitude of different political systems that could be just. We settle on one. The fact that we fairly settled on one now creates a prima facie obligation to operate within that system. And then those outcomes do impose obligation with the proviso that whoever's in the minority, we preserve the opportunity of whoever's in the minority to become the majority. And that's kind of, but there's no way getting around the fact that we have to have settlements of these questions, and that it's better if the mechanisms for settling are more fair rather than less fair, and that there's a presumptive weight in favor of whichever mechanism we have chosen until we choose to change the mechanisms by the mechanisms, right? But that's really the best I can do in like a quick answer. Again, all with the minority rights part built in, that there has to be a way to change it, right? If it's entrenched, then it becomes more and more problematic, I think. Yeah. Way in the back, did you still want to?
I was just going to say, from public point of view, it's clear that there's some laws, like laws against child abuse or something like that, are pretty much universally accepted, that there's an obligation to obey them, and people would refrain from that type of activity anyway. But if you're on a highway and everybody's going even close to the speed limit, that's because there's a cop car that's the mugger, right? The public might agree there's a policy reason to have some type of speed limit. But if they're going that speed limit.
Yeah, you're right. So, I mean, first of all, I wouldn't on the universality of child. I mean, obviously, unfortunately, there are many people who, don't obey such laws, and even societies that have vastly different views about what counts as child. Even in 2025, right? There are things that go on regularly in other cultures that here would consider child abuse, and maybe the other way around too. With respect to, yes, so there's actually a fascinating debate within philosophy of law, or I guess I'll say a fun debate, fascinating debate about like whether the speed limit is the number on the sign or is the number at which people actually get pulled over, which is, in a more sophisticated way, say the sum total of the practices by the police and the prosecutors and the judges and all of that. And that's a lot of fun.
Well, actually, Dave Perlman, who does training for the courts now, but used to train law enforcement, he would start out and say, if the speed limit's 70, who would give me a ticket at 75? And maybe when you get up to about 80, somebody'd raise a hand, you go, what county? I'll make a note.
All right, very good. So, so I'll just say, but I'll just push back a little bit. Maybe it's like an appropriate way for the formal close of this, but okay, is it true that the reason people are still within 10 miles of the number posted on 10 miles an hour of the number posted on the sign is because there's a cop or they think there's a cop, or but I still think for all my criticism of Hart, and it is extensive, and in fact, part of my criticism is that even the non-positivists take on too much of Hart. And so I want to roll back, talk about like, you conservative want to turn back the clock. Oh, I sure do on this, right? Like this is, yes, let's go back to law's command, right? No, nobody's with me on that, right? But I do think that Hart, for all my criticism, I do think that Hart is right. That law is not like the mugger. That law does carry with it, and it should. But as a matter of descriptive sociology, as he says, but also as a normative matter, law does carry with it a sense of obligation. And what I said to one of 6 students who asked me something like this after class, I said, to live in a free society, we need most of the people to obey most of the laws most of the time. Otherwise, it can't function. And we could have a police state that accomplishes that, but then we wouldn't be a free society anymore. And I think the reason we do have such a society is because it's not all people worrying about the cop hiding around the bend. And insofar as it is, that at least I think it is that way, or at least it should be that way. And so I think that thinking about law in terms of the common good is to promote this idea that there is a reason to obey the law, and that will hopefully motivate us to have a society where most of the people obey most of the laws most of the time, and thereby uphold our freedom. Okay, let me say thank you now, and I'll talk to you right after. Okay? Yeah, great.
So
Thank you, everyone.
Thank you, Danielle.
Thank you. Thank you.
So I think we can formally on this, and Sealy is earned and everything, but
And
to
don't.
the extent that you are willing to stick around for questions.
Yep, and I'm going to be in the back to sign books for everyone. So
Have him sign it.
have a book.
Yeah.
Even if you don't want it signed, please have a book.